position of precedent in English legal system expresses that the House of Lords is the superior judicial court in England, and its every decision is binding over all the inferior courts such as Criminal Court of Appeal, Court of Civil Appeal, High Courts, all the three benches of High Court, the magistrate courts, and the county councils. In the leading case, London Street Transport Company Limited versus London County Council in 1898, House of Lords expresses that it is binding even over the House of Lords of its own previous decisions. But this tradition was changed in the most important leading case, that was Boyes versus Chaplin in 1968, where Justice Lord Denning expresses that even the House of Lords was not bound by its previous decision, but all the inferior courts are bound by the decision of House of Lords. So, if the House of Lords feels any irregularities or due to any inconveniences, it could overrule its own previous decisions, and those reasons are sitting as a committee of privilege. So whenever House of Lords sits as a committee of privilege, then it could overrule its own previous decision. So also on the substance and matters relating to any foreign law or foreign rules and regulation, then it could also overrule its previous decision. So also, if there was any ignorance of statutory law by the House of Lords in its previous decision, so also it could be overruled by the House of Lords itself. So also, if any decision of the House of Lords conflicts the fundamental social philosophy of the state, then also the House of Lords could overrule its own previous decisions. These are the grounds or the reasons which compels the House of Lords to overrule its own previous decisions. In the same way, in R versus Tayler and in the Young and Brist Aeroplane Co.Ltd. case in 1944, the Lord Justice Curzon had his decision was that the Court of Criminal Appeal can reconsideration of its previous decision due to misunderstood, misapplied, and misconducted of law as it related to life and liberty of a citizens. So, the Criminal Court of Appeal or the House of Lords could overrule its previous decisions if that previous decision was due to misconstructed of any rules or laws, or if it was misapplied in case of that decisions, or if the particular rule or law applied in that particular case was a misunderstanding of the legal points, then it could be overruled by the Court of Criminal Appeal or Court of Civil Appeal and the House of Lords. And both the Court of Criminal Appeal and the Court of Civil Appeal are bound by the previous decisions of the House of Lords. In the same way, the High Court of London is bound by the previous decisions of Court of Criminal Appeal, Court of Civil Appeal, and also of the House of Lords. So also all the magistrate courts and county courts in England are bound by the previous decisions of the High Court and its 3 benches and of the decisions of Criminal Court of Appeal, Civil Court of Appeal, and the House of Lords. This is the position of precedent in English judicial system, as we discussed regarding the present position of precedent as followed by the lawyers, judges of inferior courts or subordinate courts in English legal system.